All right. Hello, everybody. My name is TJ Scott. I'm a Minnesota estate planning attorney. I own and operate the law office of Timothy J. Scott, where I help people to plan their estates. I help people to put their affairs in order so that when they pass away or if they become incapacitated before they pass away, that things are easy to manage for their family, that there's a legal pathway to manage things, and that it's not complicated, it's not a problem for their family. And I'm so pleased to see so many people joining us here tonight. If you have a question, if there's something that sparks additional questions or that you want more information about, I really invite you to ask that either in the chat box or in the Q&A box, and I'm going to be monitoring those throughout our presentation here tonight. But questions are fantastic. If you have a question, it's likely someone else here has a question. And I'm just going to ask you to please give yourself this time that you've dedicated to being with me here tonight. I encourage you to turn off any distractions that you might have. You signed up for this presentation because you know estate planning is a topic that you want to know more about. Estate planning is complex. There's a lot that has to go into it, but we're going to talk about all of it today, and we're going to break it down in a really easy to understand way. But I really encourage you to spend this time with me, spend the hour with me, bring me your questions, and use me as a resource. And I always say your future self is going to be glad that you took the time to learn and to enter into the information here with me tonight. And I want you to stay with me all the way through to the end of the presentation, because I'm going to have some offers for you. I've already shared a link to my calendar in the webinar chat. If you look for that, you should be able to find the link to my calendar. And that link will allow you to book a free virtual one-on-one meeting with me, where we can talk about the things that we're talking about here tonight, but we can talk about them in the particulars of your situation, of what's going on in your life, what's going on with your assets, the people that you love, and how you can protect them. Plus, if you stay with me until the end, I'm going to give you a bonus gift to make it even easier to get a personalized and tailored estate plan in place. We have a process that makes this so easy. From start to finish, we can be complete with your estate plan after you come and see us in as few as 4 to 6 weeks. We make this so easy, and we've helped hundreds of people to get their estate plan in place and to protect their family. And we would love to be able to help you if you're looking for help for that. So let me ask you, and I'm going to be looking for some input here if anyone wants to share with me. Again, I know that we reached out ahead of time and we already have some questions and things that we're going to be focused on here tonight. But let me ask you, what are you hoping to learn here tonight? That maybe you've done a DIY will in the past, or you're thinking about doing a DIY will through something like LegalZoom. Or maybe you're wondering, how do I choose my trustees or my professional, my fiduciaries who are going to take care of things for me? Or how do I choose my attorney? You know, what do I need to look for in an attorney? How can I be sure that I can trust that person? Or maybe you have a business and you want to know how to protect that business. You know, I have a question coming in here. What's better, a trust or a will? And that's absolutely something that we're going to talk about in detail here tonight. Or maybe you want to know what to do with your retirement accounts or how to set up beneficiaries. We are going to talk about so many things tonight, and I want you to know that you are in the right place here. Estate Planning 101 is for you if you have someone or something that you care about and that you want to protect. And Estate Planning 101 is the right place for you to be if you've done an online or do-it-yourself will, but you're not sure it's going to work the way that you want it to work, that it's not going to work for your family. And you're in the right place if you're worried about how much this is going to cost. That's okay. I'm going to speak directly to the costs you can expect to write a really fantastic estate plan here in this presentation tonight so that there's no mystery about it. The reality is, estate planning isn't really about us. And this was something that really occurred to my wife and I recently when we were updating our estate plan, that we weren't going to financially benefit from our estate plan, right? It wasn't going to enrich us. It's not like starting a business or starting a side hustle, right? But it's about the people that we love. It's about making sure that they're taken care of and that if something happens to us, they're going to be well cared for. The reality is our loved ones are going to know whether we lived up to our promise to take care of it after we're gone. And we want to make sure that the answer to that question is a resounding yes, that they're well cared for, that they have been protected. So, Estate Planning 101, we're going to cover all kinds of things here tonight. We're going to cover things like guardianship for minor children. And give me just a second here. I have a way of doing a poll. Let me just ask, do you have minor children? I just want to get a feel for how many people have children under the age of 18. I'm seeing a lot of yeses tonight. No, and then here comes some no's too, and that's okay. It looks like a slight balance, more for the no's than for the yeses. I'm seeing somebody else responding in the chat. Thank you for sharing. That more people don't have kids, and so we will talk briefly about guardianship for minor kids, but we're not going to dwell on it too much. We'll spend a little bit more time talking about things like healthcare decisions and financial decisions. We're going to talk about how to get financially organized and how high of a priority that should be for you. We're also going to talk about deciding who receives and how people receive. Wow, lots of responses in the chat. I really appreciate your willingness to share with me. We're also going to talk about how to decide who's going to receive and what the default is here in the state of Minnesota. We're also going to talk about avoiding court and conflict and avoiding estate taxes as well, because those are really important elements of a well-written estate plan. But before we get into too much detail, I want to share just a little bit about who I am and where I come from and why I know about these things. So this is me with my family. Again, my name is TJ Scott. I'm an estate planning attorney here in Minnesota. I'm pictured here with my wife and 5 kids. I graduated from the University of St. Thomas School of Law back in 2012. When I was in law school, I worked really hard, and I graduated magna cum laude, which means that I was near the top of my class and on law review, things that typically set you up for a job in big law, downtown, working something like 80 or 100 hours a week, arguing about font sizes on contracts or something like that. But something amazing happened to me the day after I commenced from law school, and that's that my first child was born. My son was born. And being there in the hospital room with my wife and with my son really helped to clarify the wishes that I had for the way that I was going to practice law, the way that I was going to approach things. I knew that I wanted to serve people, and I wanted to operate in an area and practice in an area where I could give my clients the value that they deserved. And that's where I was very lucky. I found an estate planning law firm where I was working under an attorney who had been practicing estate planning for something like 35 years. And she taught me how to write really fantastic estate planning documents. She also taught me that the estate plan itself, isn't constrained to the 4 corners of those documents. That estate planning means a little bit more. An estate plan, and an estate plan in order to work, really requires a lifetime of guidance and help. So what is an estate plan? And a lot of times people think an estate plan, well, that probably means a will, right? Or maybe it means a trust, and maybe it means a will and a trust. The reality is an estate plan is bigger than any specific documents. An estate plan is a plan for your person, your assets, and those you care for in the case that you become incapacitated or for when you pass away. It's really an umbrella term that we're using that includes things like documents, but it includes other elements as well. Things that you share with your family, the way that you've organized things, the beneficiary designations that you've set up. It really reaches out and includes a lot of things. So let me ask you this. Do you have an estate plan? And I'm going to try and do another poll here if I can figure it out. Yeah, here we go. Do you have an estate plan? Have you written an estate plan, or do you have an estate plan? And I'm seeing primarily the answer is no. I'm seeing some responses in chat. I'm seeing a lot of responses to the poll that say no, I do not have an estate plan. A few people who do, The reality is, even if you haven't written an estate plan, we all have an estate plan. The state of Minnesota prepares an estate plan for us. So even if we haven't taken an active role and done things like written a trust or written a will, written healthcare directives or powers of attorney, memorial instructions, that's details about how your body is going to be handled after you're gone, or updated our beneficiary designations or guardianship nominations, the state of Minnesota has a plan for us. And typically that plan involves court. And that's true of things like guardianship decisions. Again, I'm not going to spend a lot of time talking about guardianship because I know not all of us have kids here tonight. But guardianship is really crucial, really important to get right. If you have kids under the age of 18 and you haven't decided where those kids would go if something happened to you and your partner, the default decision is to have a judge make that decision for you. And if that means that Uncle Larry is the right person to have the kids, or Aunt Susan is the right person to have the kids, then the judge is going to make that decision and going to carry out those wishes regardless, even if you know that Uncle Larry or Aunt Susan isn't the best person to have the kids. So you should be making this decision is the point, not a judge. Make sure that you make that decision. And here's the rubric that the judge is going to look at in order to decide what's in the best interest of the child. And this looks very legalese to me, very complicated. Really, what the judge should be deciding is, what would the parents have wanted? And that's the best place for the kids to go. So that's enough talking about minor guardianship here. Like I say, I know not everybody has minor kids, and so I don't want to dwell on it too much. But this is something that affects all of us. Healthcare decisions are something that affects all of us. And if we haven't documented our healthcare decisions, if we haven't named a healthcare agent, then there's a default that the state of Minnesota puts in place for us. That default is a court process called guardianship of the person, or just guardianship. And that court procedure often involves court and conflict. You may recognize this person on the screen here. Her name is Terri Schiavo, and back in the mid-2000s, there was a significant court case and significant interest in the life of Terri Schiavo. That Terri was a young woman who suffered a cardiac event that left her in a vegetative state. She was being kept alive on a feeding tube, but her husband wanted to remove that feeding tube, and her parents wanted to keep it in. There wasn't a consensus about what was going to happen, but through a series of court cases, including petitions all the way up to the United States Supreme Court, it was eventually decided that the husband had the right to say what happened with Terri. The feeding tube was removed, and she passed away about 2 weeks after that decision was made. So that's an example of guardianship and the guardianship process. But the reality is this: we don't have to opt into that court system, and I don't recommend it. I recommend that you take power, that you take action in order to write a healthcare directive, and that healthcare directive allows you to name an agent and to name your wishes to ensure that your wishes get carried out, that somebody else doesn't have a say, like happened in the case of Terri Schiavo. For financial decisions and who's going to handle things like your bank accounts and your taxes and your legal matters, there's another court process that happens if you haven't made the decision about who's going to have those powers. And that court process is a process called conservatorship. It's a process that we may be familiar with from the singer-actress Britney Spears had a conservatorship, or her father had a conservatorship over her for a time. And that conservatorship takes away a lot of power and gives it to whoever that person is that's a conservator. But even that conservator is really serving at the subject to the whims of the court and subject to the oversight of the court. And so it's a really difficult process, not only for the person who's subject to the conservatorship, but also to that conservator who's helping the person. But you can avoid that conservatorship court process, that's likely to end in conflict either between you and the conservator, or between the conservator and the court, or between family members. And the way to take power and the way to make those decisions yourself is with a document called a power of attorney. A power of attorney allows you to name an agent who would have essentially those conservatorship type powers, be able to help by moving money between accounts, paying creditors, filing taxes on your behalf, and continuing lawsuits. And you can even specify the specific powers that you want to give to that person. But this is the way that you can avoid court and conflict. It is really important that we be financially organized. There's something called unclaimed property, and I will look here to chat to see if anyone's had any experience with this. I can tell you I have had personal experience with this, actually. That my grandfather, after he passed away, there was some property that he owned, some stock and some dividends from stock, that the family wasn't aware of. And even though the family did their absolute best to go and collect all of the assets that belonged to my grandfather, to find everything, collect it, but in order to distribute it out, some things got missed. And over time, things ended up in the Minnesota Department of Unclaimed Property. Right now, the Minnesota Department of Unclaimed Property holds something over $700 million worth of assets. It's holding over $700 million worth of assets. And a big part of the way that the assets get there is that people pass away and they are not financially organized when they pass away. So their family tries to collect everything, tries to do that person's wishes in order to distribute everything out. And unfortunately, things get missed. And when things get missed, they end up with that Minnesota Department of Unclaimed Property. There is a process by which people can actually go and make a claim and receive those assets. But unfortunately, it's a lengthy process. It's a difficult process to go through. There is a way to get financially organized and to have all of your assets clearly delineated so that if anything happens to you, it's easy for your family to handle. It's easy for your family to figure things out. And it's a process that we bring all of our clients through in our meeting process and in the process of preparing their estate plan and preparing their documents. It's a really essential moment, or a really essential element in order to make sure that nothing gets missed. And it's actually even more essential if your assets aren't a great multi-million-dollar type of estate, right? That, I am, again, a father of 5. I am still working on building the estate that I want to leave to my family, to my kids. But it's very important to me that every dollar, that every dime of that estate gets to my kids, especially since I'm still in the process of building it. This is really important, and it's not to be missed. It's a crucial part of estate planning. Another thing to consider is who's going to receive from your estate. And if you haven't made an election, if you haven't made any decisions about who's going to receive, there's kind of a way that things fall out. There's a way that things are going to happen. Your number one default recipient is typically your spouse. And this makes sense. A lot of times we own assets jointly with our spouse. And so it makes sense that our spouse would receive those assets. Plus, they have the ability to elect and to receive a significant part of your estate if you haven't detailed it to go to someone else. Kids also have a part, or descendants. Descendants also have a part of your estate, and something really complicated can happen if you have purchased your home before marrying your spouse, or if the house was purchased in just the name of one of the spouses, that the surviving spouse doesn't have the right or the title to the complete house in that case. Instead, the surviving spouse has what's called a life estate in the house, and the kids have what's called a remainder interest in the house. And this gets really complicated, that when one spouse passes away, most of us would think that the surviving spouse is going to have complete title to the house, but that doesn't always happen. If you're not married, if you don't have kids, there's a plan for you as well. And the plan is that if you don't have any descendants under you, we're going to go up to your parents' level and try and give the assets to your parents. But if your parents aren't living, then we're going to look to descendants of your parents. So we're going to look to your siblings and your nieces and nephews or grandnieces and nephews. And it kind of cascades down in a waterfall. And if we're not finding anyone there, then we're going to go up to your grandparents' level. And again, we're going to kind of cascade down into a waterfall through aunts and uncles and first cousins once removed until we find somebody to receive. But the reality is, none of that is probably tailored to the way that you want your estate, that you want your assets to go. What I was talking about was intestacy, and it doesn't likely include, the intestacy statutes, the way that Minnesota has things going, is not going to include your church. It's not going to include nonprofits that can be really meaningful to us, especially as Minnesotans. We're very charitably minded and charitably intended. It's not going to include people, if you want a gift to go to your grandkids, they wouldn't be natural recipients if your children are still living. And so if you want to do something like set up an educational trust or an educational fund for the grandkids, that's a great thought. It's a beautiful thought, and there are ways to do it, but it's not going to happen naturally under the way that Minnesota has put things. So choosing who you want to receive is really important, and you can choose who you want to receive. Who's going to receive is important, but how people are going to receive is also important. And we talked about, if you haven't named people to make healthcare decisions for you, there's a court process called guardianship. If you haven't named people to make financial decisions for you, there's a court process called conservatorship. And if you haven't detailed a specific plan to avoid court after you're gone, there's a court process called probate. In all these cases, court, because it's an adversarial process, tends to lead to conflict. It tends to lead to son fighting against daughter, someone arguing for equal distributions versus someone saying why they should receive more, somebody arguing about why we should keep the feeding tube in or why we should remove the feeding tube for mom. Court equals conflict. And I know for most of us, we want to avoid conflict in our family. The default for the way that your assets go if something happens to you is through a court process called probate. That court process called probate is there in order to make sure that you have an agent who can stand in your shoes and administer your assets the way that you want them to be administered. That person's called a personal representative. And they're going to be responsible for making sure that your creditors are paid and that eventually the assets are distributed out to your heirs or devisees or beneficiaries, the people who get to receive your assets. But the court process is really for the favor of your creditors, to ensure that your creditors get paid. And it tends to be, or it is here in Minnesota, a very long process. It takes a long time to go through. Here in Minnesota, it takes at least 6 months, oftentimes more like 12 to 18 months to go through the court process here in Minnesota. It's also expensive. That we have a way of estimating the cost of court, and we typically estimate it to cost something like 3 to 6% of the gross value of your estate that's going through probate. So let me give you a context for that. Let me give you an example of what that means. If the only asset that you have that goes through probate is a home, and that home has a value, let's say, of $400,000, well, a 3% estimate of the cost of probate, which again is on the low end of what probate's likely to cost, is that probate would cost something like $12,000 to go through. And the reason for that is there's all types of different fees that come in, or costs. For example, there's attorney's fees and filing fees. There can be bond premiums that need to get paid or executor fees that the personal representative demands. There are appraisal fees, obviously creditors want to receive. And again, it's a lengthy time to go through this probate process. And during that time, it's impossible to sell the house for a pretty significant chunk of time at the beginning. And because it's impossible to sell the house, that means that things like the mortgage continue to accrue and need to get paid. or that things like utilities need to get paid, or real estate taxes and homeowners insurance. So I think oftentimes 3% is too low of an estimate of what probate is going to cost. More often it's something like 5%, which would be something like $20,000 for a $400,000 house, or even 6%, which is something like $24,000. It's expensive, and typically we want to avoid probate. Probate's also public, and that's how I'm able to access this will. This is the will of JFK, our former president. And here in JFK's will, we're able to see where his assets go. He has a sum of $25,000 going to his wife, Jackie Kennedy. And interestingly enough, the remainder of his assets are split. One half of the remainder of his assets does go to Jackie Kennedy, but the other half, or all of it if Jackie Kennedy had predeceased, the other half goes to his children or issue. And that means that his spouse didn't naturally have the right to receive everything. Jackie Kennedy didn't have the right to receive the entire estate of JFK. And again, I get to know this because this will had to be filed publicly when it went through the probate process. But the good news is court is optional. And again, we can avoid things like the guardianship process by putting a healthcare directive in place, or the conservatorship process by putting a power of attorney in place. A will details things like who's going to be your executor. It nominates an executor or personal representative, and it says who is going to receive distributions from your estate. But unfortunately, a will does not avoid probate. In fact, we have this really goofy saying in the estate planning world. We say, where there's a will, there's a probate. If you're relying on a will to detail where your assets are going to go, unfortunately, relying on that will in order to handle things means that it has to go through the court process called probate, for the probate court to authenticate it, make sure that it was executed correctly, to actually put that executor in your shoes to handle things, and to make sure that all of the assets are disclosed, made public, and that everything is actually administered the way that it's intended to be administered under that will. Having said that, probate is still optional. You can avoid court, and there's a couple of great ways to do that. Number one, if your assets are very simple, you can probably, and the way that you want to leave assets is just to one or two individuals, and they're adults, and they're ready to receive those assets, then you might be able to plan your estate using things like beneficiary designations and transfer on death deeds. Beneficiary designations, transfer on death deeds, or POD or TOD designations are all ways to have your assets automatically transfer to the person that you have listed after you're gone. Transfer on death deed is really like putting a beneficiary designation on your home. It says, after I'm gone, I want my home to automatically transfer to, and then you name the individual. Another way to avoid probate is to fully fund a revocable living trust. And when I say fully fund a revocable living trust, I mean, number one, you have to put the agreement in place. A trust really is just an agreement. And let me see if I can do this. Let me see if I can pull this up in a way that I can actually show everybody what I'm talking about. I think I want to stop sharing here. There we go. Okay. A trust is this. A trust is that somebody starts with property and they entrust that property to someone else called a trustee. And they say, here's what I want you to do with that property. And the trustee says, yes, I agree. I will use this property in the way that you've asked me to. So a simple version of this is that I could entrust a court document to my client services director, Gretchen, at the office. And I could say, I want you to bring that court document to the court and file it for me. And Gretchen says, yes, I agree. I've entrusted that document to Gretchen. She's going to bring it to the court and file it on my behalf. And everything is in trust so that she's going to carry out those wishes. A revocable living trust is one that you actually create with yourself during your lifetime. So you start with property, things like your home, your bank accounts, your investment accounts, your personal property, things like life insurance and retirement accounts. You entrust those assets either during your life with things like your home or your bank accounts, investment accounts, or personal property into your name as trustee of your trust. And it's easy for you to agree and say, yes, I will use these assets in the way that essentially I'm telling myself to, because it's revocable. That means that you get to change it. You can take the assets out of the trust. You can detail what's going to happen and how people are going to benefit from this trust. When you pass away, you can have a successor trustee who steps into your shoes and is able to administer those assets in the way that you want. So with things like the home, we transfer that into your trust using a quitclaim deed during your lifetime. Or with bank accounts, you take a trip to your bank and you tell the banker, I want to change title on the name of my account. Will you help me? The banker says, yes, we can do that. We're going to change title, and now it's titled in the name of your trust. With things like investment accounts, again, we're going to change title. Personal property is very easy. We just sign a single document called either a bill of sale or an assignment of personal property, and we're able to put that personal property into the trust and have the trust govern what's going to happen with it. With other things like life insurance and retirement account proceeds, we typically designate those assets by beneficiary designation to go into your trust after you pass away. And there's a process for that as well. But the key thing is that we want things in the name of your trust after you're gone. Probate is only required if the assets that remain in your name at your death have a value of more than $75,000. So oftentimes we'll leave things in your personal name, like your vehicles, for example, that they often don't add up to $75,000. However, if you're getting close to that number, we may want to transfer even some of your vehicles by changing title on that vehicle so that it's also in the name of the trust. So that's what a revocable living trust is. It's a way of having assets that are in the name of your trust during your lifetime. So when you pass away and a successor steps into your shoes, they're able to administer those assets without having to go through that court process called probate. Everything is very clear and very private, and that they're able to administer the assets in a really clean way. Let me figure out how to share back. Let me figure out how to share back to, there we are. All right. It's almost too easy here, the technology. Okay, we got it figured out. All right, thanks everybody for your patience. Good. So if anybody has any questions about that, I know that that's kind of a dense topic. It's kind of a confusing topic, but that way of showing the transfer of the pen is one of the easiest ways that I've found to show it. We should talk briefly about estate taxes here. The good news is that estate taxes don't apply to most people. And in fact, we need to do a little bit of adjusting here. 13.99 million is no longer the operative number. Nowadays, actually, the exemption on the federal level is $15 million. And if you're married, good news, you get to actually double that number. So the number is actually $30 million. So most people, estate taxes are not going to apply to, but if they apply for you, absolutely reach out. It's something that we're going to want to get in front of, to get control of as soon as possible, to make sure that your estate has to pay the least estate tax possible, because the rate is exceptionally high. As you see, the rate transitions from 18% at the start of assets over that $15 million or $30 million, all the way up to 40%. It's a very high rate, and we want to avoid it at all costs. Here in Minnesota, we also have an estate tax. Luckily, the estate tax exemption here, or the estate tax rate here in Minnesota, is lower, but the exemption is also significantly lower. That the estate tax actually kicks in at about $3 million, and it's not portable, meaning that we don't get to automatically double that number if we're married. We have to do some planning in order to double that number. So, we have talked about a lot of different topics today, and we have even more questions that have been asked and that we're going to talk about here in just a minute. But talking through all these questions, maybe something has resonated with you. Maybe it's something about court. that's resonated with you, and the desire to avoid court and to avoid conflict. Or maybe it's things like the estate taxes and the cost of estate taxes, or the complexity of going through probate and the web and the mess that that creates. Or maybe it's the cost of probate and the idea that your estate is going to be automatically diminished right away by something like 5% of the assets there by going through that probate process. Maybe you don't feel comfortable with not getting to decide where the kids are going to go and live if something happens to you. That you know Uncle Larry is not the right person to take the kids, but you're not sure that a judge is going to see things that way if something happens. Or maybe you don't want Aunt Susan making healthcare decisions for you, but you know that under a guardianship type process, she may be the person that gets selected to make those decisions on your behalf. All of this might leave you thinking, I know that I need to do something, and how am I going to get it done? And you have options. One thing you could try to do is DIY some kind of estate planning solution, or you could look to hire an attorney, and keep in mind, not all attorneys are the same. So should you DIY your estate plan? Obviously, I'm a little bit biased. Estate planning is what I do for a profession, but I can tell you, as a professional, the number of DIY estate plans that I've seen go wrong is tremendous. It's sadly a lot of estate plans that I've seen go very wrong very quickly. I always say trying to do your estate plan by yourself is like trying to put IKEA furniture together without the instructions. There are so many different pieces that need to fit together, that need to work together in order to make your estate plan work exactly the way that you want it to. And they need to be in the right spot. And I always like to tell a story about, I call it my fishing story, that I wanted to take my son fishing. And so we had ordered some new fishing rods and reels, and I had a plan to take him. But those rods and reels, they came without any fishing line on them. That's not a problem. So I ordered new fishing line and went down to the basement and started to wind fishing line onto that rod and reel. And right when I got to the end of the fishing of the reel, I thought that I had enough on there. I went to clip the line up at the top of the rod. And I don't know what I did wrong, but all of a sudden that fishing line started jumping off of the reel, and I had, this isn't an actual picture, but I had something like this picture, a mess of fishing line on the table in front of me. Again, I don't know what I did wrong, but I do know this. I failed that DIY project. But it was okay because I was able to fix it right there that morning. I was there and I was able to take things into my own hands. And I was able to fix it. I had to cut loose some tangled fishing line that was on the table in front of me. I maybe lost something like 35 cents worth of fishing line, but it was okay. It only took me something like 2-3 minutes in order to untangle things enough that I could clip it loose. And my son and I were still able to go fishing that same morning. The reason that I like to tell that story is because I am a do-it-yourselfer. I like to try to do projects myself. I understand that drive. I understand wanting to do that. But that project was totally different from writing an estate plan. If your estate plan goes wrong, you are not going to be there in order to fix the problem. And I can tell you, it's not going to take 2 or 3 minutes to fix the problem. It's going to take months. And it's going to take months of court to try and fix the problem, if it can even be fixed. And it's not going to cost something like 35 cents worth of fishing line. The cost is going to be thousands of dollars. It's going to be attorney's fees, and it's going to be a lot of hurt feelings and conflict in your family. And none of us want that to happen. And you don't need that to happen. You don't need to try to go the DIY route because you can afford an attorney. It is more affordable now to hire an attorney than it ever has been in the past. With things like word processors, we are able to write an estate plan, and estate planning truly is for everybody. There was a time when you had to complete an estate plan using triplicate carbon copy, and if you made a single mistake on the page with the typewriter, you had to tear it up and start all over again. That's not the case anymore. It is more affordable, it is more approachable than ever, but you want to make sure that you're hiring the right attorney to write your estate plan. Planning with a typical estate planning attorney typically means you're going to get form documents that are kind of set it and forget it. You may not know what they mean exactly. You'll probably tuck them into a bottom drawer somewhere and just hope that they work for you when the time comes. It's not a great plan. Working with a typical estate planning attorney isn't going to get you financially organized. That's just not part of what most estate planning attorneys see as part of their service to their clients, which means that the Department of Unclaimed Property may end up with some of your assets. Working with a typical estate planning attorney may avoid probate, or it may not. In fact, a lot of estate planning attorneys have probate as an alternate way of raising revenue in their firm. I do probate in my firm, but I don't enjoy it, and I do everything in my power to make sure that the clients that I work with are not having to go through that painful court process called probate. Typical experience probably isn't going to keep the family out of conflict. It means leaving the assets to heirs unprotected. Typical experience isn't going to include ongoing legal guidance because those attorneys often will charge hourly fees, and they'll start charging hourly fees as soon as you call back and have a question for them, which is not a great way to foster a good attorney-client relationship. Working with a typical estate planning attorney is not going to adequately protect your kids. It will often end up having a judge making decisions if it comes down to guardianship for minors. And it's going to leave you with this awful question that you don't need to have in your life. That awful question, is my plan going to work when I need it to work? Planning with us is totally different. It's a totally different experience. We don't charge hourly fees. We charge flat fees, and you are going to choose that fee based on different packages that we offer. The fee is typically somewhere between $2,500 and $6,000. And I understand that that's an investment, but again, that's approachable. That's approachable for all of us. You can get a fantastic estate plan written for no more than $6,000. I know we can do it. I know we can take care of that. And most often people are significantly lower than that. Oftentimes people are around $4,500 for a full revocable trust plan that's going to keep your assets, that's going to keep your family out of probate, out of court and conflict. Planning with us means keeping your money out of the hands of the state, that we get you financially organized so that you avoid the Department of Unclaimed Property with your assets. If you have minor kids, it means protecting those kids totally in the immediate and long term, short term and long term. It also means keeping your family out of court and conflict. That's really important to us. I've seen probate, and I've seen the way that it can create conflict in families. And as somebody who is a peacemaker, I want to help be a peacemaker in your family. I know how important it is to make sure that we avoid probate, that we avoid other court processes like guardianship and conservatorship. Planning with me means knowing that you've made the right decisions, because we're not going to make the decisions for you from some kind of form document. That we are going to empower you and walk through those decisions with you and help be a counselor to you so that you're making the very best decisions for yourself, for your assets, and for your family. Planning with us means the option of protecting the family money from outsiders. Things like a divorcing spouse or creditors in bankruptcy. We want to help you protect the inheritance that you want to leave to your loved ones. And planning with us means a lifetime of guidance and protection. Because we charge a flat fee, we're able to include ongoing guidance and help and advice about your plan into the future. Planning with us means that you know your plan is going to work when your family needs it to work. And isn't that a relief? Isn't that worth paying somebody to know that your plan is going to work when you need it to work. So if you want to make this happen, if you want to get a great estate plan in place, there's a few things that you need to think about. You need to think about guardianship for minor kids. You need to think about who's going to make healthcare decisions for you and what kinds of decisions you want them to make. You need to think about who's going to make financial decisions for you and what powers you want them to have. You need to get yourself financially organized. You need to decide who's going to receive. You need to make a plan to avoid court and conflict. You need to make a plan to avoid estate taxes. You need to make a plan to avoid nursing home care costs. Or you can just call TJ. You can just set up a time to meet with me and we will help you and we will help make sure it's taken care of. Not all attorneys are the same. We focus on providing client value. We focus on being peacemakers and peacekeepers in your family. And we focus on being a continuing resource to you and to your family after you're gone. We have flat rate, fixed fee packages that we charge, and we take care of things, help take care of things for you. So I see a few questions coming in here. I want to make this really easy for you though. I want to make it really easy for you to get some time on my calendar. And so I'm going to reshare the link to my calendar right now. And I want you to click on Family Wealth Planning Session when you look at that calendar. And you may see, you're going to see there aren't any more times here in February. We're almost at the end of February. And that the times in March are starting to look a little bit picked over. I think there might be something like 6 more time slots, maybe a few more than that are still available coming up here in March. But there's greater availability as you start to look out to April. There's greater availability as you look out to May. I want you to get this scheduled, and I want you to get it scheduled as soon as possible so that you keep the momentum going, that you keep things moving forward. That family wealth planning session is a 2-hour-long meeting with me where we're going to talk about the things you have and the people that you love, and we're going to talk about how you can protect them. The first part of our meeting, we're going to talk about what would happen if something happened to you right now. And what is the ideal that you would want to have happen? What is your ideal estate plan? And between those two, between what's currently the reality and what your ideal is, we can talk about different estate planning tools that we can use in order to get you closer to your ideal. If you schedule that family wealth planning session, and if you schedule that family wealth planning session before the end of the week here, and when I say end of the week, what I'm talking about is the end of the day, Saturday. We're going to do some follow-up with you. We're going to do some emails and ticklers, but really, I want you to grab the time right now so that it's not so picked over by the time that you get to it and by the time that you book your time, that you're not getting a time that works for you and works for the people that you love. And I understand if you need to coordinate with a spouse, I understand needing to coordinate and find a time that works. But still, I encourage you to just grab some time right now and then ask your spouse and find out if it works. If it's not the perfect time, that's okay. We can get it rescheduled. We can find a time that's going to work for you. But I want you to do that. I want you to do that soon. And if you do, if you get on my calendar, again, your actual meeting time is not going to be before the end of this week. I'm already booked up here this week. And like I say, things are starting to look pretty picked over in March. But if you get that time reserved before the end of the day, Saturday, I want to give you $250 off the estate planning package of your choice. And I want to do that as a gift to you, but also because it makes my life a little bit easier. That right now we have a fair number of people on this webinar. And if I needed to follow up with each and every one of you with calls and emails, it's going to take my time. It's going to take some additional attention and focus in doing that. And it's difficult. And I want you to keep the momentum going, but it's difficult for me to continue that follow-up if you're not going to show that this is something that you're really interested in, that you're really looking to get this done here in 2026. But if you schedule an appointment with me, you will know the next step that you need to take. You will already be taking the next step that you need to take in order to get things handled, in order to get things resolved. So I'm going to take some time and I'm going to answer some questions. There are questions that I'm seeing here in chat right now, and I'm going to prioritize some of those. But there are also questions that came to us in email or by phone earlier before our presentation here today, and I want to speak to those a little bit as well. So one of the questions that I see asks, does the lifetime of guidance include updates over the years? And unfortunately, the answer to that is no. I don't know what your future holds. It's possible that it may require frequent updates. We've had clients before that have required frequent updates for one reason or the other, but that takes significant work. It takes time and work in order to get that done. And I just don't know what the future holds. That lifetime of guidance does include is ongoing communication, ongoing guidance about what your plan says, and about when we need to look to make updates. And so that includes complimentary reviews of your estate plan every 3 years to make sure that it still says what you want it to say. But like I say, unfortunately, it does not include updates to those plans. I see someone saying, I live in Wisconsin, can you represent me? I can. We can work together if we work through co-counsel there in Wisconsin. But honestly, oftentimes what that means is you're better off working with a Wisconsin attorney to write your estate plan. The laws for estate planning, the laws for wills and probates and trusts are all state specific. And I am an attorney here in Minnesota. Unfortunately, I am not licensed in Wisconsin. So it's, again, not impossible for us to work together. That if what I've said has resonated with you, if we've built some trust here tonight on this presentation, and you know that you trust me to quarterback your estate plan, I would be honored to help you write your estate plan. But we would have to bring in some help from Wisconsin to make sure that I'm getting the law exactly and precisely right, and that I'm getting it exactly and precisely right in the ways that most benefit you. Another question is, any cases where an estate requires a trust rather than a will? There are often times that a trust is a more preferential estate planning tool than a will. As I shared in this presentation, if we're relying on a will to handle your assets after you're gone, then we're probably looking to probate as a process. There are times when we look to things like beneficiary designations and transfer on death deeds in order to plan estates, and that we often will write a will as kind of a backup document in those cases. But if there are some cases, by the time that you own your home, a lot of times we're looking at whether a trust is a good solution to your estate planning needs or not. If you have a home and significant financial holdings, things like stock or investment accounts, or even just bank accounts with significant amounts, tens of thousands of dollars, like I say, a lot of times we are looking and considering whether a revocable trust is a good estate planning tool for you. But we explore all things. A trust is only a tool. It's like a hammer. It has a purpose and it serves that purpose really well. But if we're trying to get a screw into a board, a hammer is not going to be the right tool to do that. So it's one of the tools that we consider when we look and design your estate plan. It's a great tool for avoiding probate and can be a great tool for doing other things like planning for estate taxes, holding assets for people who are too young or too immature to receive them, or giving out assets to a longer list of people than one or two people. It's a really great tool for those things, but it's not the perfect tool. It's not the only tool that we consider. Another question I see here is interested in hearing a bit about irrevocable trusts. So we've been mostly talking about revocable trusts here tonight. An irrevocable trust is one, I always liken it to something on train tracks. It's something that you set in motion and it's just going to do what you have set it out to do. But you can't make changes to it anymore. You can't take assets out of that irrevocable trust anymore. You're no longer the beneficiary oftentimes of that trust. You're no longer the person with control of the assets in that trust. But this person is asking, my parents ended up being on county medical assistance and the county took all of their assets. Is an irrevocable trust the only way to keep the county from taking all the assets if you need medical assistance, such as being in a nursing home? That's a really great question, and you're not the only person with a question similar to that. That we had somebody else ask similar questions like, is my primary home protected from Medicaid if I end up in long-term care nursing home, or will Medicaid place a lien on my home if I need to receive medical assistance or Medicaid here in medical assistance here in Minnesota? Should I transfer my home to my family now? These are all very good, very difficult questions. We do help people with elder law issues in my firm. We do help people and talk people through medical assistance and how to keep as much of your assets as possible and keep as much of your assets in your family as possible. Irrevocable trust can have a place in that planning, but they're relatively new instruments. They're not new instruments. Minnesota has not always had a very good law regarding irrevocable trusts. And so for a long time, irrevocable trusts have been treated as if they didn't exist at all here in Minnesota. And Minnesota Medical Assistance and Estate Recovery has just gone after those assets and collected those assets anyway, even if they were in an irrevocable trust, even if you gave up control of them, even if you weren't the beneficiary of them anymore. The state of Minnesota didn't care. It was going to go and collect those assets anyway. So things have been changing more recently, and irrevocable trust planning has started to have more of a place here in Minnesota. But there are other types of planning that we can do as well. There are ways that we can use things like Medicaid eligible annuities in order to change an asset from an asset to an income stream instead. There are ways to house the value or the equity or our assets in things like the equity of our home, that we can do that up to $700 something thousand. There are a lot of different planning options, but a lot of times my recommendation isn't to take such a radical step as transferring all of your assets out of your name and into something like an irrevocable trust or into something like one of your kids' names. But that's pretty extreme, and you can't take it back once it's done. There are instances where it makes sense to do it. And there's something called a 5-year look back period for medical assistance and Medicaid that we want to be aware of. But it's generally my practice to not encourage my clients to impoverish themselves prematurely. And instead, there are things that we can do in order to plan and in order to take actions if we need to in the future. Again, using things like Medicaid eligible annuities and some gifting, even if it invokes a penalty period, there are some really good things that we can do to preserve your assets in the future if nursing home care becomes necessary. But sometimes we do use irrevocable trust, having said that. So that's a great question. Other questions that I sometimes get, or that I get, one of the questions that I got that I think is one of the most fantastic questions to be asking. And that question is, what mistakes do families commonly make before coming and seeing me? I would say one of the most common mistakes that people make is either number one, trying to DIY their estate plan themselves. I have read some doozies. I've read situations where people have reversed the order of how they have people receiving to the point where the sister that they wanted to receive their personal property ends up not able to receive anything because of the way that things are worded in kind of a backwards way, and end up leaving her disinherited from the estate. I've seen estates before where we get the legal description. It wasn't me that wrote it, but I've seen before where people have gotten the legal description wrong on a property, on a home. And so instead of trying to transfer lot 4 of block 1 to their family members, they tried to transfer lot 40 of block 1, 40 of block 1. And the county said, I'm sorry, there is no lot 40. this transfer on death deed has no effect and it's not going to do anything, and we're not going to honor it. And that meant that instead of having things be simple and governed by that transfer on death deed, we ended up having to go to probate and argue with a judge in order to try and get that transfer on death deed reinstated. And that took thousands of dollars and a significant delay. It really took a long time to go through that process, unfortunately, in the court in order to try and get that remedied, in order to try and get that fixed. So I would say one of the most common mistakes that I see is people trying to DIY it, trying to go their own way and do it themselves. They educate themselves, they Google so many things, they show up to so many presentations, and because they're trying to get it done themselves, when in reality, the reality is you will probably write one estate plan in your life. I have already written dozens of estate plans this year. And last year I wrote hundreds of estate plans. And the year before that, I wrote over 100 estate plans that I know the tools to use. And I'm not just going to take the wheel. I'm going to bring you along on the process and talk you through and empower you to make the decisions that are right for your assets and for your family. Thoughts on reverse mortgages and bad idea for a TOD. I think that probably means like a transfer on death deed, maybe. Reverse mortgages have a place. They do have a place. Accessing the equity in your home at certain times, there's a good reason that you would want to do that. And there are good things that you can do by accessing that equity out of your home without having to sell the home. There are some times when you're able to get some kind of a reverse mortgage annuity that is able to help you pay through periods that you wouldn't have had any income and still remain in your home for the remainder of your life if that's what you want. So there are definitely places for reverse mortgages. They have a really bad reputation, and unfortunately, there were, I think, some unscrupulous kind of salespeople of reverse mortgages that earned that bad reputation by pushing them on people even when it didn't make sense to use them. But so they do have a use case, but the use case can be kind of narrow, and we've used them with some of our clients, but in select cases, and making sure that it was the exact right situation. If you do have a reverse mortgage, know that you are drawing from the equity of your home. You are reducing the equity, you're reducing the value of the home, which means that any kind of inheritance that you're hoping for your family to receive from the equity of that home is going away during your lifetime. And again, there are times when that's a reality, it's a sad reality, but it's a necessary reality that the assets should be used for you. You were the one who earned those assets and grew those assets during your lifetime. And so even having a transfer on death deed attached on that reverse mortgage doesn't mean that the mortgager or the mortgage company isn't going to accelerate that mortgage in order to get paid after it transfers by transfer on death deed to your family. So it's really a balancing of priorities and a balancing of options to use things like reverse mortgage or transfer on death deeds. Transfer on death deeds are a great tool, especially if you're only leaving the house to one or two people or an organization. If you're leaving a house to an organization, sometimes people will leave their home to somebody like or to like their church or to a charity in order to have that charity arrange the sale of the home, collect the proceeds, and get to use those proceeds. And so sometimes that happens, and it can be a good thing. Or if you're just leaving the house to you only have one child and you're leaving the house to that one child, great. When you start to leave the house to more than two people, things start to get really complicated, because everybody that you leave the house to transfer on death deed to has an interest in that real estate. And their interest in that real estate means that they are going to have a say in what happens with it. They're going to have a say of whether somebody goes and lives in the property, or whether it's sold, or whether it's used as rental property. Everybody has a say, and it can be like herding cats if you have more than two people who are involved. And in fact, even if you have two people involved, it's often more than that, because spouses have an interest in the real estate that their spouse owns here in Minnesota. And so it does start to get really complicated if you have more than two people that you're leaving a house to in a transfer on death deed. Another question here with the reverse mortgage: is there a set time period where money owed on the reverse mortgage has to be paid back? It's a good question. Typically, the answer is no. That with a reverse mortgage, the understanding is that you are going to be permitted to remain in your house for the remainder of your life. But that means that with a reverse mortgage, you're often not able to access the entire equity of the house. That there's a certain percentage of the equity that you're able to access, something like 50 or 60%, for example. And so there's no time period where they're going to require that it get paid back, but when you pass away, that money will need to be paid back. They're going to want their share out of the house. And there are ways to do that, even if you're leaving the house to kids. For example, the kids could refinance the home, or put a new mortgage on the home in order to keep it and pay off the reverse mortgage that was on it. There are options still available, but that's typically the answer is no. There's no time during your lifetime, but after death. That's right. Clarify, after death after death, is there a set time period? It's pretty quick after death that they're going to want to get paid. That you have passed away, their contract has come to fruition, and now they want their money. That their money has been held up, during that time period as equity in your home. So it is. They move pretty quickly after you're gone in order to collect the money that they've forwarded. Yeah. Okay. Again, I really encourage you to take the next best step here today. I'm going to share the link to my calendar here another time. I really want you to schedule that family wealth planning session, and I want you to set aside 2 hours for that meeting. That's why it has a $750 value. But again, I don't want to focus on that. I want to give you that family wealth planning session for free. I want you to have the opportunity to come and talk to me about the people that you love and the things that you have. And we'll talk about what your current reality is, what your current estate plan is, and what you want your estate plan to look like. And we'll talk about the ways that we can help to write a great estate plan. And at about the hour mark, we'll talk about what the cost of that estate plan is. If you want to hire us, great. And most people do. Most people say, yes, TJ, we see the value that you provide and we want to hire you. We want you to write our estate plan for us. That's great. Like I say, most people do. But there have been situations before where I've had people come in for a family wealth planning session, and I've said, I don't think that you need to write an estate plan at this time. It doesn't seem to worry you that you don't have somebody to make healthcare decisions for you. It doesn't seem to worry you that the assets are naturally going to go to your brothers and sisters or whoever is going to receive. It doesn't seem to worry you that your brothers and sisters are going to have to go through probate. So it's not my recommendation that you write a plan. I've made that recommendation before. I've had those same people end up coming in, a year later and say, I've really reviewed things. I've really kind of revised my thought on it. And maybe I don't want my family to go through probate. Maybe I do want things to be a little bit easier. And we're able to arrange that too. Absolutely. But I just want you to know, the family wealth planning session is free. There's no obligation to continue. If you're going to book that family wealth planning session with me, I want you to keep that appointment. And I want you to come in and see me. Even if you feel like you don't have an estate to plan for, even if you're not sure that you want to hire me to be your attorney, that's okay. It's okay to come in and talk to me and just get some information and do some learning and do some digging. I want to be a resource to you, and I want to help you to take the next best steps to get your estate plan in place so that there can be peace in your family, that your family can avoid court, can avoid conflict, and that you can give the gifts that you want to give to your family. The gift of peace, the gift of your assets and receiving those assets in the right way. And again, I want to give you $250 towards the plan of your choice if you choose to write a plan with me. And the way to secure that $250 discount, again, is by clicking through my link right now. I really want you to do it. I really want you to just take the time, as long as you're here with me, or scan the QR code if that's easier. Whatever works. But I just want you to take the time to take the next best step here. That it probably took you some time to get to this presentation, to get to the point where you said, you know what, this has been on my to-do list for too long and I'm ready to take another step. I'm ready to start working on this, right? It takes time, and I understand, and it's often something that falls off of our estate plan because even though we know it's a priority, a lot of us don't feel like it's ever going to happen to us. Unfortunately, someday we're all going to pass away. We're all going to be gone someday. That's a sad reality, but it's a reality. And it's a reality that we can face with confidence if we have a plan and if we know what it means for our family, if we know what it means for us when that happens. And we can provide that answer. We can provide you so much peace. We can provide you knowledge about what exactly is going to happen, but you've got to take the next step. You've got to book that meeting with me. I can't give you that information, other than what I've provided, I suppose, already here today, unless you follow up, unless you schedule that meeting with me. So thank you everybody for being here tonight. Hopefully I reached most of the questions that you had. Like I say, there was quite a good selection of questions that were emailed or relayed to us by phone earlier. If I didn't specifically address your question, or if you have more specific questions and you want to get answers to those, again, the best way to do that is by scheduling the family wealth planning session with me. But in other ways that you could do it, certainly you could schedule just the 15-minute consultation if that's the right speed for you, or just emailing me or giving a phone call into the office as well. I'm seeing lots of thank yous for the information. Thank you for being here on the call tonight. Your family thanks you for getting this information and for taking the next step with it to make sure that they're well cared for. I really appreciate everybody joining me here tonight. This was a great group, and we really had a lot of people here on the call. So thank you again for being here. I look forward to meeting with you. I look forward to helping you write a great estate plan and take care of your family in the way that you want them to be taken care of. So I look forward to meeting with you soon. Take care.